gives me pleasure to be with you today. I hope that the sound is good enough. This is Mahmoud Sabra speaking. Thank you very much for coming. My topic will be medical liability from the perspectives of law, the courts, and jurists. One in 14 doctors faces a malpractice suit every year. I'll say this again. 1 in 14 doctors faces a medical lawsuit every year. This is a study which was published by the New England Journal of Medicine in 2011. This is bad news, of course. This simply means that sooner or later, a doctor will find himself in a court of law facing a medical law suit against him. Let us...
Welcome to the list of the 5 biggest medical mistakes ever. Number 5. 49-year-old Donald Church was admitted to the Washington Medical Center in Seattle due to a tumor he had on his abdomen. After his operation, the tumor had thankfully been removed, but something else was there instead. One of the surgeons had unfortunately left a 13-inch retractor in his abdomen and stitched him up and sent him on his way. Fortunately, the surgeons were able to remove the retractor, and Mr. Church suffered no long-time health problems due to the mistake. The surgeons admitted to leaving the 13-inch long retractor in Church's abdomen, and the hospital agreed to pay him nearly $100,000. It wasn't the first time Washington Medical Center had done this, and 4 similar incidents happened there between 1997 and the year 2000. This type of medical failure unfortunately happens quite often all over the world. For example, one such victim was told he had multiple retractors in his stomach. Oh, and there's the case where a German patient named Dirk Schroeder had 16 objects left in his body, which included a swab, a roll of bandage, and even a surgical mask. I can understand one item being accidentally left in someone, but 16? It's pretty much like they emptied the whole medical rubbish bin into his abdomen. Number 4. A 67-year-old woman was admitted to a teaching hospital for a routine diagnostic test. It was to see if she had any blockages in her blood vessels that could possibly lead to a heart attack. The day after the procedure, she was mistakenly wheeled in for an operation that was meant for someone else. See, after the initial test, the patient was mistakenly transferred to another floor, rather than being returned to her original bed. So on the morning she should have been discharged, she was actually undergoing an operation. That operation was open heart surgery. The patient was 1 hour into someone else's operation, and at that point they had already made an incision in her groin, punctured an artery, and threaded a tube into her heart. It was at that point the phone started ringing. It was a call from a doctor in another department who was very angry and wanted to know what the hell they were doing with his patient. The confused surgeon operating on the woman checked the chart and realized he was making a pretty large mistake. Open heart surgery is a very risky operation with the possibilities of an infection or lung or kidney failure, but luckily the patient was returned to her bed in a stable condition. Number 3. Stacey Gillette of Brooklyn, New York went to the Winthrop University Hospital for the removal of an ectopic pregnancy and left the hospital as a double amputee. Both of her legs were amputated just below the knee after a doctor punctured her abdomen, which led to an infection and then ultimately caused gangrene in both legs. Stacey is now wheelchair bound and was awarded $62 million. $20 million for past pain and suffering, $38 million for future pain and suffering, and another $4 million for medical expenses. Obviously, $62 million is an incredible amount of money, but it doesn't replace her legs, and Stacey was happy justice was finally served. Number 2. November 2007, Rhode Island Hospital. An 86-year-old woman died 3 weeks after a surgeon operated on the wrong side of her head. The lady needed the operation to stop the bleeding between her brain and her skull. The neurosurgeon at the hospital started the procedure by drilling the right side of the patient's head, even though a CT scan showed bleeding on the left side. See, mistakes like this are few and far between, but for the Rhode Island Hospital, it was the 3rd time in the same year that this had happened, and all by different surgeons. One of those was a surgeon in training who decided to skip the pre-op checklist and ended up operating on the wrong side of another patient's brain. An investigation was launched and Rhode Island Hospital was eventually fined $50,000, and the hospital has since re-evaluated its training procedures. Number 1. This medical mistake happened in the University Community Hospital in Tampa, Florida, and it was one of the most publicized surgical mistakes of all time. 52-year-old Willie King had an operation to have his leg amputated, but when he awoke they had amputated the wrong leg. Whilst the surgeons did realise halfway through the surgery, it was already too late and the leg was removed. It was due to a long chain of errors, and the surgeon claimed he was just following what was written on the board and on his sheets. As a result, the surgeon's medical license was suspended for 6 months, and he was fined $10,000. It gets worse though. Willie King still needed that amputation on his other leg, so he was eventually left as a double amputee. Willie was eventually paid $900,000 in damages, and the surgeon had to pay him an additional $250,000. And that brings my list of the 5 biggest medical mistakes to an end.
As we could see from these 5 deadly errors in medical practice, the common element is negligence. But negligence can be defeated. Remember this all the time. In all the 5 deadly errors, if hospital protocols were followed, negligence could be defeated, could be avoided, and no harm could happen. I'm sure that no one of you will be pleased if a patient is harmed. I am sure that your profession is to make people happy, not to make them suffer. Your profession is to heal people, to make them recover, not to make them live bad times. Now, types of medical errors. Let us have a bird's eye view on what we mean by medical errors, and if there are different types or only one type. We can say that medical errors, we have different types of medical error. An error, for example, can be an act of omission. By saying an act, we mean that something that the doctor does. But let us not say the doctor, let us say a bad doctor. Simply, it is my point of view that medical errors never happen by good doctors. They always happen by bad doctors. So when we talk about medical malpractice, actually we talk about good doctors versus bad doctors. So please don't say a good doctor committed a medical error. If an error is committed, it is simply committed because of 3 main elements which cannot be attributed to a good doctor. Number 1, ignorance, according to Act 12 or 28 here in the Emirates. So a doctor cannot be described at all as ignorant. If he is described as ignorant, he does not deserve to be even called a doctor. Number 2, ignorance. I want to ask if there is any one of you who wants to have the picture about himself as a negligent doctor. Doctor by profession cannot be negligent. Number 3 is what we call lack of duty of care. I will come to discuss these points in details. But so the first error is an act which is committed by doctor. But also, a doctor's failure to act can be an error. For example, if a doctor fails to treat a patient or doesn't intervene to treat a patient in an emergency situation. This is a medical error also. Intentional or unintentional. Most of the medical errors are unintentional. And this is, adds to the catastrophe of medical malpractice. I will repeat this again. Most of the medical errors are committed unintentionally. And good news, the courts do not impose criminal liability against those who commit unintentional medical errors. But this is not a guarantee, because simply the court may change its mind if it finds that the doctor did not take enough precautions, was negligent, and even was not very, very attentive when he was practicing his job. Second or third, gross or minor professional error. In the past, the courts used not to hold a doctor accountable for minor errors, but this trend has changed. Now the courts punish the doctor even if he commits a minor error. So it doesn't count whether the error committed is a minor or a gross error. For example, if you forget a sponge in the abdomen of a patient, this is a medical error. If you forget a pair of scissors, it is also a medical error. If you commit a medical error which takes the life of your patient, it is also a medical error. So it doesn't make a difference at all if the error is minor or gross. Also, we have what we call strict liability and or strict liability for errors, and errors that have to be proved. Usually, for a lawsuit, a medical lawsuit, to win, error should be proved. But there are cases where error need not to be proved. For example, if you use a tool which is contaminated and do not follow the procedures, do not follow the protocols. In this case, you are responsible for the tool which is contaminated, and you didn't follow the procedures to make sure that it is not contaminated. So strict liability simply means that we don't have to prove the error. The error is established against you whether it is proved or not. Another example may be when a doctor works with a team of assistants. If any wrong is committed by an assistant, a nurse, for example, a technician, for example, etc., it is the responsibility in the final analysis of the doctor also. So here we can say that liability is assumed, or we can say it in legal terms, there is a strict liability. In a malpractice lawsuit, does the type of error make a difference? I want to hear an answer. Again, after we discussed the types of errors, in a malpractice lawsuit, regarding, of course, medical liability, does the type of error make a difference? Can you tell me?
I think it would make a difference. If it is a minor error, not life-threatening.
Yeah, if it is a minor or gross.
Not life-threatening.
Yes.
With not major complications, would cause.
So you see that it makes a difference. It's the type of error.
Yes.
in medical liability. Do you share her opinion?
Yeah, I think it depends what type of error. If your patient died or she's just injured or she had a minor problem, it should be different.
It should be different.
An error has happened.
Mike,
An error has happened. But this error has not caused any, ill health or problem to the patient in such situations.
So, simply, can we say that the type of error makes a difference whether to punish the doctor or not? Can we simply say that the doctor has not to be punished simply because the error committed is simple, is minor?
One more thing.
If harm is done, of course, we assume that harm is done.
Suppose this error which has happened, it is not because of negligence.
Yes.
Many a times these things do happen in the profession, especially when it comes to surgical field,
Yes.
where surgeons operate on a field, on a patient. Many a times, it may be urologist, it may be gynecologist, it may be general surgeon. Many a times, these are things which are known all over the world. These are known to occur many a times. They are out of the control or hands of the surgeons. Unintentionally, these things happen, which are correctable. Many a times they get corrected with these things, and very rarely the patient may get into a permanent disability or complication.
Thank you. The idea is in home now. So, certainly, let us.
Can I add something?
Yes.
Yeah, the basic issue here is to err is human and to forgive is divine. It's very hard for us to forgive each other, but to err is errors do happen and will happen again. The issue is the type of error, whether it's intentional or unintentional. A physician will hardly ever make an intentional error unless he's intoxicated or under the effect of drugs. Unintended error also has grades: minor, major, adverse, and sentinel. And there also, we have to open it completely through a root cause analysis, through a peer review, internal, external, and see the professional liability of that physician involved. Depending upon the professional liability involved, that will determine the quantum of punishment.
Thank you, Dr. Mirza. Simply, let us look at this point from the legal point of view. To be held accountable in criminal law, you must have committed a crime. The definition of crime is that it happens whether by intentional act or unintentional act. So it is not correct to believe that errors do not give rise to criminal liability. Criminal liability exists even if the error which has been committed was unintentional. So remember this all the time. Criminal liability is simply based on negligence, lack of precautions, recklessness, etc. So if one of these elements happens, it means that you will be held liable under criminal liability. So let us move to another point. Medical malpractice, what does it mean? I have already said that it means a good doctor versus bad doctors. It means simply departure from the right standard of care. It exists when a doctor does something that a doctor shouldn't do. Medical malpractice is defined in Article 14 of Act 28, and the three causes are mentioned, or three elements. Number one, ignorance of technical matters which a doctor should be aware of. Number two, negligence. Number three, failure to observe duty of care. Often I am asked about the difference between negligence and failure to observe duty of care. Many people do not know the difference between the two elements. Simply, when we talk about criminal law, we use the term negligence. But when we talk about civil law, we use the term duty of care. So it is just difference in the law or in the liability, in the type of liability that is imposed. In civil liability, a doctor may be punishable by damages or paying money as compensation. But in criminal liability, for example, he may also be punishable by paying, but in this case we call it fine, not damages or compensation. And of course, he will be punishable or may be punishable by imprisonment. So imprisonment only exists when criminal liability is established. But when criminal liability does not exist, there will be no imprisonment or fine. So simply, we use the words or the term duty of care in civil code and the term negligence in criminal code. If negligence is established, this simply, if the term even is used, this simply happens, or this simply means that the doctor will be punishable by criminal law. But I have good news for you. The recent trend shows of the courts, especially, not of the law. The recent trend of the courts show that rarely criminal punishment is imposed against doctors who make unintentional errors. Very rarely. But almost always, criminal liability is imposed against intentional acts. So, if a doctor commits a crime, a doctor like any other person, whether in the course of his doing his profession, or outside even of his profession, like let us give examples, like a doctor when in illegal abortion, for example, this is a crime by the law, and this is intentional act, so it is punished under criminal law. And sometimes, if the error is unintentional, but leads to the death of the patient, or to a certain degree of disability, which means gross damage, gross harm to the patient. In this case, the courts usually tend to impose criminal liability. But a study of the recent trends of the courts, at least in the embassy here and in most Arab states, show that the courts rarely do not tend to impose criminal liability or criminal punishment, which means simply imprisonment, on doctors who make unintentional errors, except in case of gross negligence. In case of gross negligence. Let us see this difference between a good practice and a bad practice.
What do you mean? I don't know what you're trying to talk about. That's ridiculous. I don't.
Hi, Michelle.
Please.
I have some letters for you.
Yeah.
Patients.
Okay.
Miss Brennan agrees with CB.
Can I borrow your pen?
Okay, sure. She needs heparin.
Stop. That's so. Leave me alone.
Daily that starts today.
Okay.
And Mr. Sharma.
Would you shut up? Stop being so rude.
The one that's going to surgery. He's anxious, so we just want to give Valium to him.
Okay.
IV push.
All right. Thanks. I gotta go. It's been really busy today. Talk to you later. Okay. Heparin value. Okay. All right. Heparin value. It's 10 milligrams. All right. Looks about right.
here she puts the two. And then mistakes.
Which is what?
Yeah.
Hey, Skinner, what's up? I got some value for you. For what? Oh, you're just way too anxious. Please, back off. Back off. Buddy, please. I gotta hold you down. Where's your IV? Okay, here you go, buddy. You'll feel great in a few minutes. Yeah, I know. It's just been waiting. It's just crazy today. I don't know what's going on. What's the way on?
Did you have a patient, Cameron 361A, who passed away during surgery?
Really?
He ended up leading to that. So
Wow.
there was a 90-death condition that happened, so.
I don't know. I gave him this Valium. I tried to calm him down. Okay, I'll tell you. Sorry. Man. Oh, yeah. Nurse? Yeah. Can you come in here? Okay. I don't know what you eat is so good right now. Really? Yeah. Huh. I feel like loving. I just want to touch your face. You're weird. I don't know what to tell you. I'm flying though, like, are you supposed to feel like this? Usually not, but maybe you're that rare chance that you will. I don't know. You might be alright though if you just relax. I have no idea what's going on. You have like 4 eyes. Thanks. It's really creepy, but I don't even care.
This was about
Yeah, I
that
did go
nurse.
trick-or-treating this year. I was a
Let
bunch
us
of
see
kidding.
a good nurse.
Hi, Stacey.
Oh, okay, I gotta go. I'll call you back later.
I have some orders for you for your patients.
Okay.
First one is Miss Crennan 360B. She needs headroom 5,000 units, sub-Q, daily from now on.
Okay, so Miss Krein 360B is to receive 5,000 units heparin sub-Q daily, is that correct?
Right.
Okay.
And then the other one, I have Mr. Sharma in 361A. He gets Valium 10 milligrams, IV push, once before he goes to surgery. It's a little anxious.
Okay, so Mr. Sharma needs to get Valium 10 milligrams IV push once, is that correct?
Correct.
Okay, thank you.
Have a good day.
Thanks, you too. Okay, so Miss Krein. Heparin. There. 5,000 units. Hi, Mr. Krein, how are you today?
How are you?
Good. Can you tell me your name and your birthday?
Connor Kren, 102388.
Okay, good. I'm gonna give you your heparin today. You want it in your arm?
Yes.
Or usually get it?
Yep.
Sounds good. Just a little pinch, push. Alright, we are all set. Do you need anything else?
No, I'm good.
Okay, sounds good. I'll see you later.
Thank you.
So as we could see, it is a question of bad practice and good practice. And negligence is very easily can be defeated. Medical liability, what does it mean? The word liability is significant in law. It simply means legal responsibility for one's acts or even omissions. Failure of a person or entity, like a hospital, for example, to meet that responsibility leaves him, her, or it to a lawsuit for any resulting damage.